So this is the third and final video in relation to Aboriginal people for the Religion and Belief Systems in Australia section of the Studies of Religion course. In this section we look at the land rights movement. So this section on land rights is kind of the opposite of the previous section, which was on dispossession. So dispossession is about the impact of moving or removing Aboriginal people from their land, and we've already mentioned how detrimental that's been to their spirituality. But we now need to look at how the land rights movement has impacted on Aboriginal spirituality as well. And we'll have a look at these following factors. So we look at the land rights movement, which initiated in 1975. Then we look at the Mabo case in the High Court and the subsequent Native Title Act that followed from that. Then we'll have a look at the Wick decision and then the 10-point plan. And essentially what we'll be doing is for each of these aspects, what we'll have a look at is how important they had been for the land rights movement, and bearing in mind the whole time how important the land rights movement is for Aboriginal spirituality, because we've already spoken about the importance of the land to Aboriginal people, because it allows them to maintain that link to their totemic relationships, to maintain their expected their responsibilities that they have to the land based on their understanding of the dreaming. So we've already mentioned how the dreaming is inextricably linked to the land, and then therefore the land rights movement is incredibly important for maintaining Aboriginal spirituality. So we start off with the land rights movement, which began with an Aboriginal man called Vincent Lingiari, and he was an elder from the Grinji people, which were a group of people that were working on a station in the Northern Territory, and the station was called Wayfield Station. And the Grinji people had been in a dispute with the owner of Wayfield Station in regards to their working conditions. They weren't happy about their working conditions they were left with, so they went on strike. Essentially, they had what they call a walkout, or walk-off rather, and they walked off from the station in 1966. Because this group of people, the Gurindji people, had actually been living on this land for a lot longer than that station had been around for, and they remained on that land the whole time. So they walked off from the station, but sort of remained in the area, and that led to a big long dispute with the owner of the station. And it was finally settled in 1975 by when the new Labor Prime Minister Gough Whitlam came in, and what he did was he followed the recommendations from a royal commission, which was the Woodward Royal Commission that had been instituted, which recommended that the Aboriginal people should be given these Aboriginal people should be given their land rights for lots of different reasons, but essentially because they'd been living on that land for so long, so they deserved that land. Their ancestors had been on that land for a very long time. So the first land rights legislation was passed as a result of this, and this was the Land Rights Act. Sorry, passed in 1976. It was the year after Gough Whitlam had met with Vincent Lingiari, who you can see here pouring sand into his hand as a symbolic gesture of returning the land to him and the Gurindji people. So 1976, the Aboriginal Land Rights Act was enacted. So again, this is very important because in terms of Aboriginal spirituality, because it was the first step in a long path for Aboriginal people gaining back some of their land, at least, that they had lost due to European settlement, which would enable them to reconnect with the dreaming and restore some of those broken links as a result of the European settlement. Getting back the land was so important to these Aboriginal people because, again, this is the medium through which the dreaming is communicated to people, and it also allowed them access to their sacred sites to fulfil those ceremonial and ritual responsibilities that they had to the land and to their community, which came forth from the dreaming. So the next section that we'll look at is the Mabo decision, and this happened in 1992, and this was based on a guy called Eddie Mabo, and he was from the Miriam people, which is from sort of Mer Island, which we call Murray Island in Queensland. And what he did was he took his land rights case to the High Court of Australia, who eventually ruled in favour of Mabo in 1992, which was just after he'd passed away, unfortunately. And Mabo, the Mabo decision is incredibly important to the land rights movement, because what it did was it overturned that what they call the legal fiction of terra nullius. So what it says was that terra nullius should never have existed in Australia. It should never have been claimed by the British who settled Australia. The notion of the empty land or the land belonging to no one should never have been claimed, and that was a legal fiction, and therefore it's no longer in existence now. So that's really, really important too, because what it did was it sort of laid the path open. If terra nullius has now been made void, it sort of opened the doorway, I suppose, for other Aboriginal groups to seek land back and native title back. So native title is the term that we use for land that would traditionally belong to these Aboriginal people. So what it did was allowed under Australian law, that it sort of showed that native title does exist under Australian law, and that could lead to Aboriginal groups claiming placing a claim for land as a result of this, if they could demonstrate that they had a continued link to the land that they were trying to claim for. So following this, we had the Native Title Act, and this was in the year later in 1993, and it was Paul Keating's Labor government who passed the Native Title Act, and this was to put into law the decision that was brought forth from that High Court Mabo case. So in other words, it was trying to provide strategies so that native title decisions could be granted to Aboriginal people under certain circumstances. So what it also established was the Native Title Tribunal, and they were the body that was supposed to oversee claims of native title by Aboriginal people. So they were supposed to sort of facilitate it if Aboriginal people were trying to make a claim for native title for their community. So there's a couple of things that we need to understand about the Native Title Act. The first thing is that native title could not be claimed on freehold title land, which means that if you're the permanent, you're the owner of land, and you own your block of land, or you own that 50 hectares, and you're not leasing it from anyone, but you are the owner of that land, then native title could not a claim couldn't be made under the Native Title Act on that land. So that was the first thing. And the other thing is that native title could not be inconsistent with the way the land was currently being used. So what that essentially meant was that if the land was being used for another purpose, for example for mining or for farming or grazing or something like that, then there was an issue there with the Native Title Act. So what that essentially meant was it really limited the amount of land that could be claimed under the Native Title Act. So it meant that the only land that really could be claimed was Crown land, which means it's land owned by the Australian government, that was not being used. So what that did was it really limited the amount of land that could actually be claimed by Aboriginal people. So that was the first sort of stipulation on the Native Title Act. The second stipulation was that native title could only be claimed on this vacant sort of Crown land, where Aboriginal people could claim a continuous connection with the land prior to European settlement in 1788. So they had to essentially show that them and their community, their clan, had been living on that land that whole time, which was very difficult to do because Aboriginal people have not kept sort of the kind of records that the European people wanted to see for this sort of thing. So that was the first thing that made it really, really difficult to do that. And it was also really, really challenging as well because a lot of these Aboriginal people had been already forcefully moved off their land. So it was sort of kind of difficult to claim that association with the land over that long period of time. So that sort of further made the amount of land that could be claimed by Aboriginal people under the Native Title Act as being very, very small. So essentially the Native Title Act sort of really limited the amount of land that Aboriginal people could claim for. But it was still, despite the limitations placed on the Native Title Act, it was still a really important step for Aboriginal land rights because it did sort of make it possible for some groups to claim native title under some circumstances. However, the making Aboriginal people to try and show that they have a continuous link and association with that land was the really limiting factor of that legislation. So it's important too to remember that some people don't think that the Native Title Act went far enough, because it doesn't provide Aboriginal people on communities with an opportunity to claim the rights to access to land. So it's not about ownership, but more about access to sacred sites in particular, that are under freehold or leasehold land. So that leasehold land is land that's leased from the government. And so what some people think should happen is that Aboriginal people should be allowed to have access to those sacred sites so they can conduct their rituals and ceremonies and fulfil their obligations to the land that way. Even if that land is freehold, which is owned by someone, or if it's leasehold, it's leased by someone, they should still be able to gain access to that land to conduct their rituals and ceremonies and therefore fulfil their obligations from the dreaming. So even despite the limitations, the Native Title Act has still been an important step for Aboriginal people. It's helped people gain social and economic independence as a result of the Native Title Act, and it's sort of really opened a doorway for Aboriginal people to preserve their culture and to reconnect with their spirituality through their connection to the land and their kinship groups. The next step for Aboriginal land rights was the Wick decision, and this came through in 1996 when the Wick people, again from Queensland, from Cape York, they went to the High Court of Australia and they gained the ruling in their favour. And what the Wick decision ruled was that, as we mentioned previously, native title couldn't be claimed on freehold or leasehold land. A leasehold land is land that's owned by the government but is on a long-term lease to a mining company or to a farmer, pastoralist, so a farmer or a grazier. So if the land is freehold, which means it's privately owned, or it's leasehold, which is leased from the government, it couldn't be claimed. And what Wick determined was that leasehold title was not protected from native title, which meant that Aboriginal people could claim on leasehold title land, could claim native title on leasehold title land, and that in fact, and what that would mean is that native title wouldn't take over that leasehold title, but would coexist with the leasehold title, so that they would sort of share title of the land. The Aboriginal people would have the native title, and the people who were leasing the land would have that leasehold title of the land concurrently. This was really important and had a massive impact because about 40% of Crown land was actually under leasehold title. So what that meant was that it actually opened up a lot more land that could potentially be claimed by Aboriginal people under the Native Title Act. However, the issue with the Wick decision was that when there was a dispute over how the land was being used, the native title holders and the leasehold titles couldn't agree on how to share and divide the usage of the land. Then the leasehold rights would supersede those of the native title holders. So it still held, I suppose, the balance in favour of the leasehold titles, but it did have a step forward for Aboriginal people. So under the John Howard's Liberal government, which was in power in 1998, they introduced what's commonly referred to as the 10-point plan, but its actual title is the Native Title Amendment Act. And this was introduced because a lot of farmers and mining investors were lobbying the Howard government about the potential impact of the native title claim. So this was introduced into Parliament to try and placate these groups. And what the law allowed for was for a transfer of rights from the federal government to the state governments, which would upgrade the leasehold title to freehold title, which meant that people who were worried about, or groups that were worried about losing their land or losing part of their land or having to share land with under the Native Title Act under WIC would could actually transfer the rights. The federal government could actually give the state governments the right to change that from leasehold title to freehold title, which would mean that those people could no longer claim for that land at all. Couldn't even share the land, which they could under the Native Title Act. So that decision really made it far more difficult for Aboriginal people to claim native title, because it allowed the federal government to give the state governments permission to change it from leasehold to freehold title. It also introduced a sunset clause as well, the 10-point plan, which gave a date by which native title claims had to be made by. Otherwise, they sort of forfeited their right to make land rights claims or native title claims. So this had a pretty big impact. The Native Title Act changes brought about through the 10-point plan really reduced the number of possibilities for people to claim native title. And the long sort of court process that were involved in claiming native title really precluded a lot of Aboriginal people or Aboriginal groups who just could not afford to pay the lawyers to conduct such a long and lengthy legal process. Finally, there's another sort of small dot point, which is the significance of the land rights movement to the Dreaming, which is essentially, it sums up all the information that we've just looked at and links it back to the Dreaming. So even though it's kind of a separate dot point, it really is just what the questions are going to be asked like, I suppose. It's just how the questions are going to be focused. It's about applying everything we've looked at in terms of land rights and linking it back to the Dreaming. Again, we have to remember that the Dreaming is inextricably linked to the land, and that the land is the mode through which, or the mode or medium through which the Dreaming is communicated. Within the land lives the ancestral spirits. People have their totemic and ritual and kinship responsibilities that they have to fulfill, and that's all connected to the land as well. They have these obligations to the land. So as a result of all that, all of these steps forward have had an impact. The land rights movement has had an impact, but when you're judging your impact, you're going to talk about the potential for each of these, but how in a lot of cases they were limited by legislation. So you would talk about how the 1975 there's a lot of potential for people to reclaim their land, but then you can talk about the Native Title Act and Mabo decision and how they started limiting some of these options as well. Particularly that the 10-point plan, which really limited opportunities for Aboriginal people to reconnect. They're the kind of words I suppose you'd want to use: re-establish their spiritual and cultural links to land, reconnect to the Dreaming, etc., etc.